So you don't have to raise your hands, but think to yourself about your assets and your family and how you want your family to receive those assets if something happens to you, you're disabled, or you pass away. In your materials that Kirstin passed out is a worksheet, and that is your ticket to basically getting your questions answered. And because some things that we're going to go through today will be things that apply to you. So if you see yourself on that, mark it on your worksheet, and Kirstin will collect those, and she will schedule a time to speak with you and see if this is something we can help you with. I'm Donna Jewett. I want to thank you for coming. I want to thank Juan. I am amazed at everything you put together. You're amazing. I am told lots of hard work, charm, and good looks. And I thank you so much for having us.
Be here.
All right, so. Line it up this way. Okay, I skipped them. So the last one is a picture of me. I've been an attorney for over 35 years. I've been practicing here in the Valley. Our offices are in Scottsdale. I have been an estate planning attorney for about 7 years. It's a wonderful practice. And so we have, through the years, developed a lot of expertise. Specifically, what we're talking about today are revocable living trusts. There are plenty of other advanced estate planning things that we may want to talk about, depending on your life and your assets and what you want to do with your assets. An overview. I guess the question is, why are you here? I want to get clear on the next steps here, and there are no surprises. We're talking about the title to your home. We're talking about your kids and your family, talking about the money in your bank, talking about things that you may have like life insurance policies, investments, and the like. If anybody has questions as we go along, I'm happy to stop. All right, so I have questions of you. And we already asked that. Do you currently have an estate plan? And if you don't have an estate plan, mark the worksheet in front of you. And I'm going to tell you, the state has a plan for you. And we all like what the government does for us, right? They always do the right thing for our property. All right, question number 2. If you don't have one, why not? Too busy? Right here, you think you're too young? You're not too young. And I'll tell you why. Are you over 18? Yeah. And your mom can't make your medical decisions if something happens to you. So you do want to get a plan in place. And I know I'm picking on you a little bit, but nobody's too young. If they're over 18, even your kids, you want to make sure you get a plan in place for your kids, because you can't make decisions for them if something happens to them medically. Are you too busy? I'm going to say you all are probably really busy people, but it is worth taking the time out, and we will make sure that we walk you through that process in increments, in bite-sized increments, so that you can get a plan in place and get it funded so that it does protect your family. And is it too expensive? Okay, I'm going to tell you, dying in Arizona, we looked this up, costs you $18,000 to die. An estate plan is not that expensive, and probate will cost you probably another 25 to 50. Well, not you. You won't be here if your family's in probate, but it'll cost your loved ones $25,000 to $50,000 to get all of the stuff that you worked for back into the control of the people that you love. And question number 3, what do you hope to learn today? You want a better understanding? You want to talk about online planning? Do you have a plan and it's outdated? Those are all things we probably need to discuss. So along with the questions, we have fears surrounding estate planning. Number 1, planning will hasten my death. Statistically, there's nothing that supports that. And I've not experienced that. I have, over the years, had clients make a plan and then pass away. Most of those people knew that it was imminent. I have had a couple of unexpected deaths, and it has made a bunch of difference financially and while grief is going on, to be able to process that death without the difficulty of having to go through probate. Okay, number two, big fear, it will take too long. It doesn't take too long. I'm not going to lie to you. It takes some of your effort and some of your work, but we support you through that, and that's why your plan will succeed. And then here we go again, front row, I'm not old enough. Now you probably are wealthy enough. So, but he thinks he's not old enough, but you're wrong. You're over 18, so I'm picking on you a little bit there. Okay. So you are in the right place here. If you have someone or something that you care about and you want to protect. Doesn't matter if your something is big or small. In Arizona, just going to tell you, anybody here not a homeowner, all of your houses have more than $75,000 in equity. If you die and your house is not in your trust, your family will have to go to probate to get access to that house if it has more than $75,000 in equity. And I think thanks to Juan, all of our houses do. You're also in the right place if you did a fill-in-the-blank will and you're not sure if that will work. Because I'm probably going to tell you it may not work. And if you have just a will in place, your family will end up in probate anyway. You're also in the right place here if you are nervous about how much this costs. But what you need to be concerned about is what it costs to die without your plan in place. It will cost your family tens of thousands to get your property back to their control and in the way that you want. And it may not be the way that you want if you want to put special protections in place for your kids. You can't do that through the state's plan. So the reality is, estate planning is really not about you, because you're going to be gone. It's about the people you love the most. Now, you may not be gone. You might be disabled. And if you don't have something in place, part of your estate plan, to tell your loved ones how you want things to go if you're disabled, I want to be over here. I don't want to be over here. I want these services. I don't want these services. I want this medication. I don't want this medication. I want this one to choose, not that one. If you don't have that in place, that could happen to you also. But your loved ones will know whether you lived up to your promise of saying, I took care of you, because we all told our family that. Okay, so what happens next? I'm going to tell you some stories. I have some before and after. So I've built family stories. We're going to take them through some things that you may recognize in your life, some things that could happen, some things that maybe have happened to you, some things that maybe will never happen to you. And if they never happen to you, we're blessed. And then we'll talk about after and how we could have done better for them. So let's jump into this. Meet the Bliss family. Mark, Molly, Alexander, Benjamin, and Caroline. And they're a blended family. Molly had Alexander before she was married to Mark. Benjamin and Caroline are the children of Mark and Molly together. Then they also have, living in this house, these two, Rio and Whiskers. And okay, you know, Alexander has a dad that wasn't Mark. Let's talk about him. That's Xavier, okay? And he was kind of a party animal. And he never really grew up, and that's why that relationship didn't last. And now they have Alexander, who's 15, and he kind of stayed that fun college guy, but he did one thing that's responsible. He got life insurance, and he got $1 million of life insurance. How many of you all have life insurance? You don't have to raise your hand, but life insurance is a good thing. And he kept it updated. And he didn't want that $1 million policy to go to Molly because she's an ex. And Raise your hand if you do want your money to go to your ex. Nobody, I didn't see any hands on that one. So he made it payable to Alexander. Anybody have a problem with that? All right. Well, out of that divorce from Molly and Xavier, she got the vacation home in Lake Tahoe. So she owns that in her sole and separate name. Even though she's married to Mark, that's her sole and separate property. That's a reasonable thing to do. So they kind of look like a lot of us. Happy family, visits dad, visits mom. They do fun things together. They have a ski condo. Okay, but here we go. Sad stuff happens in families. Okay, so I have 5 sad days. Unless Kirstin gives me one of this, then we'll have less sad days. But what's going to happen? First thing happens, Xavier turns 40. Now, that in and of itself is not a sad day. But he goes skydiving because he never really outgrew it. And what happened to him? He did. And remember that life insurance policy? No, he still had it. But what do we do? Do we give it to the 15-year-old? Because he's a one-time skydiver. Otherwise, they would have just said, no, we're not going to insure you, right? Okay, oops, too far. I've gone too far here. Let me get back to my teenage millionaire. So Alexander's 15, and what's he looking for now that he has $1 million? Exactly, what color? My notes say red. Exactly. But can 15-year-olds have money? Right, they can't. So where do we go? Court. And so somebody is going to be in charge of his money. Remember, he didn't really want Molly to do that. So court involves judges. It's a lawsuit. Who is going to choose who's going to manage Alexander's money? The judge. Well, Molly's likely. She's his mom. She loves him. She looks after him. Okay, well, Zachary is his brother. And he comes in and he says, no, judge, pick me. He didn't want Molly to manage this money. Pick me. But the court looks at, the court's going to start examining Molly's finances and Zachary's finances, bankruptcies, all of his financial history. So we don't know who the judge is. We don't know the answer. We don't know who the judge will choose. It could be somebody completely different. And if neither of those are good candidates, mom, Uncle Zachary, they could choose a stranger who charges to watch that money. And that would kind of bug me a little bit more. Okay, so if you have life insurance and it's for the benefit of minors, mark it down on this worksheet. If you have minors that you want to manage money for if something happens to you, mark it down on this worksheet because you have to make decisions. Kids can't own money and they would buy a red car anyway. All right, let's do something better for the Bliss family. So number 1, he named Zachary as the beneficiary on that $1 million policy. Now what happens? Anybody know? Zachary's supposed to do what's right for his nephew. Will he? He will mean to. Okay, what if Zachary gets sued? What if he doesn't pay his credit cards and they sue him? He owns $1 million and it's in his bank account, even though he, of course, would have turned that over to Alexander. Okay, so maybe that's not a good idea. He's not required to keep that money for Alexander. It's truly his money. And it's a bad idea because it's exposed to lawsuits, creditors. Oh, what if he gets divorced? No, she wants $500,000. That wasn't what his dad meant. That wasn't what Alexander meant. Out goes $500,000 to the wrong person. Okay. Xavier said, okay, how about a will? I'll sign a will. I'll leave everything to Alexander. If he's under 21, I want Zachary to be in charge. So he had a will. Well, a will's probably a really good idea, but it's not going to keep him out of court. So here we go, back to probate court. Your will does not control your assets. The judge does. Okay. You all are in the real estate business. Let's talk a little bit about titling of joint ownership and beneficiary designations and your will. When someone calls after a loved one has passed away at my office, the first thing I want to know is not whether they have a will. I want to know whether they have a trust. And the reason is because if they have a will, you have to go to court. So you're going to start shelling out lawyers. How do lawyers charge? By the hour. Do you know how much it's going to be every time they take a phone call? $75, something like that, to take a phone call. That's horrible. Okay. So anything that you don't have just will go into this bucket and the judge decides. All right, so the big myth is that a will keep you out of probate court. It won't. A will land you squarely in court. Judges, lawyers, possible fighting, disagreements, all of the above, all of the stuff you see on TV. All right, so idea number 3. This is what Xavier did. He gets a trust and he says, I leave everything to my son, Alexander. If he's under 21, I put Zachary in charge. Same thing he said for his will, completely different result because of the instrument that he used. And that's how you keep your family out of court. This is also how you keep your family out of conflict, because you're writing specific instructions. So there's no Zachary owning this money, his ex-wife trying to take half of it, because the trust owns this money. So Zachary's ex-wife, who's now leaving, or Zachary's credit cards, they can't get at this because it's not Zachary's. That's the difference, and that's how you protect your family. Okay. A trust is a will substitute, but you don't go to court. If you put your house in your trust, you don't go to court on the house. So your trust is like a red wagon. If you go through life and you accumulate your toys and you put them in your red wagon, and you can't pull that red wagon anymore, somebody else can pull that wagon for you. So in Xavier's case, he put his life insurance into his trust, and when he died and he couldn't pull this anymore, then his brother pulled it. And he just kept on moving with it, and it didn't become part of the state. So our 3 buckets again. You put your jointly owned assets into your trust. Instead of your beneficiary designations being to a person, you designate the trust. For example, life insurance or bank accounts, IRAs. There's a little bit of technicality with IRAs, but we talk about that. And so all of your assets are now immediately available to your loved ones. No court, no permission to anybody, no asking a judge, no waiting for 4 months to pay creditors, nobody knocking at your door. They're all available now. As long as you have everything in your wagon, they're all available to your family. The assets that are in your red wagon will be for your family. So let's bring it back to Xavier. He had the life insurance, he put it in a trust. He doesn't just leave it that way. He updates the beneficiary, says, the trust is my beneficiary. Now when he dies, the right thing happens. So if the toys are outside the wagon here, if you didn't put them in, you're going to have the same problem, and you're going to have conflict again in your family, and a judge is always conflict. Okay, we solved their problem for the life insurance, but this family, they keep having problems. They go skiing, they go to the Lake Tahoe condo, starts out very fun, they're having a great time, and they bring their friend Dina with them. She's a longtime friend of the family. She doesn't have any of her kids, but she loves all of their kids. Everybody's having a great time. Starts out fun, and a fog descends on the mountain. And Mark and Molly, mom and dad, who are going downhill very fast, lose sight of each other because of the fog, and before you know it, Mark and Molly totally collide into each other. And now they've got a completely skiing gone bad accident here. And where are the kids? We're in the ski school. Mark and Molly are parents of minor children. Okay, so what happens in an emergency? Where do those kids go? Any ideas? Yep. You think the friend does? The state. You're right. Right, because Dina has no permission to have those kids. She's as related to them as we are. So here comes Mindy. Mindy is she's who they've named as a guardian, but she's a long ways away. So again, who takes the kids while Mindy's on her way? The state. And the state, somebody wants the kids, they have to go to court and say, I want these kids and I have the right to have these kids. I'll take good care of these kids. And again, you have a judge deciding and not you. And then who's left behind here with a pet sitter that doesn't know that they're not coming home? You can prepare for this as well. All right. If you have that situation with your kids and something happens to you and you have minors, write this down on your worksheet and let us know so that we can help guide you on something like this and we can answer your questions. And then I'm going to do something better for the Bliss family. Because Mark and Molly put a short-term guardian emergency plan in place. They named Dina, their friend, as a guardian and said that she can have the children if something happens to them. And so putting them with Dina, they've given an indication they feel like their children are safe with Dina. So she's along on the vacation. They're not in the state of Nevada or California, depending on what side of their line they're on in Lake Tahoe. They're not in that state's custody. They're with Dina. They know Dina. They trust her. She can tuck them in while Mark and Molly are in the hospital. And when you do that, if you have minors, we want to make sure that those people have copies, maybe on their phone, so they can show a police officer at an accident or something like that, that they have permission to have those kids. And they did a little plan for their pets too. So they don't have to go to the pound because they made plans that if something happens to us, we want our neighbor to have our pets. And maybe there's a little fun for the neighbor to have the pets. All right, you ready for next sad day? We fixed that one. All right, Molly's injuries linger. Mark recovers, but Molly is still unconscious and suffering from her injuries. Let's see. Mark is making the medical decisions. Husbands and wife can make medical decisions for one another. We don't have to have that in writing. They usually let us at the hospital. But he has the whole emotional burden of the experience, and he's not doing well. And he calls Mindy. Remember, Mindy is her sister and can have the kids. She wants to know what's going on with Molly so she can help make these decisions, but she doesn't have a HIPAA release. So there she is. They won't give Mindy any information so that Mindy can help Mark. So if you have somebody that you want to help your spouse, maybe it's your grown kids, maybe it's your sister, maybe it's your mom or dad, to help your spouse if something is an overwhelming situation and maybe they're the cooler head, you want them to have a HIPAA release so that they can look at your records, maybe consult a second doctor, and help make the decision. Yes?
Can you elaborate on HIPAA for those who have never heard of the term?
Absolutely. So a HIPAA is the release. I don't know the technical term for what it stands for, but it's a federal release that we sign so that some other person can look at our medical records. And that allows them, in this particular case, to help make a decision or to weigh in or examine those records, because when you're 18, for example, when your kids turn 18, you know, we've been taking them to the doctor, making all those decisions, that light switch goes off. And now if you think you have a 19-year-old kid and something happens and he or she hasn't signed a HIPAA release for you, and they haven't signed a medical directive for you, you can't help make that decision. You have to go to court. HIPAA release will allow you to see the medical information. It doesn't give you the right to make a decision. That's a different set of documents that you sign. But this is somebody you trust to look at your medical records. I don't know if you've ever experienced that when you go in. Sometimes they'll ask you who else can look at these, and sometimes you put your spouse in there. So that's what they're doing there. All right. But Mark can't access all of the financial documents because they have separate accounts. So he can't get into her accounts, and the medical bills are piling up, and he doesn't have her savings information, and he can't access her online, so he can't do anything. So what does he have to do? Back to court, back to the judge saying, let me have access to Molly's accounts so I can pay our bills, because they had separate accounts. So if you have separate accounts from your spouse, if you want somebody to help with something happening to you medically, put that on your worksheet, because that's something we need to talk about, because all of these what ifs you can see can happen to any family just by walking in the bank alone and opening that account. And if that turns out to be your family operating account, that could shut down your family in about a month. All right, so let's do something better for the Bliss family. This is kind of a nightmare. Say, Mark has Molly's medical power of attorney, and he's making her decisions. Even though Mindy's there, she can help with and give her views, and she can be as loud as she wants, but Mark's ultimately going to make the decision because Molly set it up this way. Yes, I want you to hear from my sister. I want her to know because I think she could be helpful. But Mark, at the end of the day, you follow my wishes. So now Mark's driving the bus medically. But the HIPAA release allows Mindy to call the doctors and find out what's going on. Mark is also named on the HIPAA release, and even though she's not Molly's medical power of attorney and can't make the decision, she is able to make suggestions to Mark and to be helpful. Now, she also, Molly, signed a financial power of attorney, and that lets Mark have access to her accounts. He can walk into her bank, even though it's just in her name, with his medical or with his financial power of attorney, and he now has access to this account. So he can pay the bills, access the balance, sign the checks, set up an online access for himself so that he can move forward. So, yes, ma'am.
Is the power of attorney, does it only come into play in this event in case Molly is unable to make decisions for herself? Then that power of attorney comes into play, or?
Yes, in this particular case, he only chose to have, or she only chose to have it if she was disabled. You can have a power of attorney, a durable power of attorney that is in effect now. So that, for example, if you were going to take a trip to Europe, but at the same time you were going to be in Europe, you were going to be purchasing a house, you would sign a power of attorney for somebody who can act right now. You're not disabled, but they can execute everything you need. And maybe you needed to go make another withdrawal because more fees came up or something on that house. They could do all of those things that wouldn't stop that transaction from going through. So there are two kinds of powers of attorney financially that we can make. One, we call it springing, which is springs into action at the disability, or the other one we call a general durable power of attorney, which means that person can act for you instantly as if they're you now. So good question though, because yeah, there are two kinds and you want to think about those as you're making these decisions. All right, number 4. I only have 5, guys. All right, Molly didn't make it. What's that? You knew it was coming.
My granddaughter's dog is Molly.
Oh. Do you have an ex-wife? I can change this.
You will be my mother.
Okay, we're not doing that. I'm just gonna make a name here, and her name is Jeff or Sherry or something like that. All right. Okay, so I'm sorry Molly is passing away, but the doctors delivered the news. And so who makes the decision? Molly is in their judgment irreversibly and terminally injured. So what happens? This is when she doesn't have any documents in place and she hasn't expressed her wishes. Who makes the call when we're supposed to remove her from life support? It could be her spouse. They may have to go to court because her 15-year-old son might have something to say and he has representation. She has the other minors, they're represented by Mark. But what do we do? What's the right answer? The probate court would have to make a decision. And you guys, not very many of you in the room are old enough to remember the whole Terry Schiavo thing. So there was this lady in Florida, and she was injured from a series of strokes. She was very young. And her husband said she's terminally injured, she's in a vegetative state, and she wouldn't want to live this way. She told me so. And her family, who had religious beliefs that you don't pull the plug or withdraw want to do that because of their religious beliefs. They're like, no, that's not our choice. That's God's choice. So they went back and forth for over 12 years through the court because she was 27. She didn't have something in place that said, if I'm in a vegetative state and the doctors come in and say, I'm not, you can't get me back, she would have said what she wanted. Keep me on support, or I want hydration and food, but I don't want this or that. You can make those choices. Some of those are religiously determined, but because her family, her parents had a different religious belief system than her husband, it was 12 years of court and a judge finally decided. And they would, I'm not kidding, take the hydration and food away. And then they'd run and somebody else would get an emergency order from a different court, higher up, add it back on. And so they were doing this to this woman for over 12 years. And in this case, who's going to be Alexander's guardian? Because remember, Mark isn't his dad, and his dad already passed away. So what's going to happen to Alexander? His grandma wants him. Is that a good idea? Maybe, maybe not. And the house, that was Molly's from a previous marriage, and it's her sole and separate worksheet. If you have assets from a previous marriage or relationship, put it down on your worksheet because we'll be able to help you, guide you through that, because you will want this not to end up in court. So with grandma, she has to go to court and ask to be the guardian. Mark wants to go to court and he wants to have the vacation home, but he splits that with Alexander. And who's running Alexander's estate? Zachary. And if there's something in place, if there's a trust in place, well, then the funds would go in there. But if there's not, Zachary's running that. It goes into a conservatorship. Judge oversees it. And at 18, $500,000, because I decided this was worth $1 million, $500,000 is released to Alexander at 18. And he does have his fast red car. So that is the mess that can happen. He wants a Ferrari. Can you get a Ferrari for $500,000? You tell me. Okay. He gets a red Ferrari and he can't drive it very well because he can't drive a stick shift and he grinds all the gears. All right, guys, let's do something better for the Bliss family. All right. First of all, Molly said what she wanted to do. And she said in this circumstance, I don't want to live if I am terminally injured or terminally ill. I don't want to have this kind of support. It's not me. I'm not here. And so we know what she wanted because she expressed it She had it written down. She had a plan. So if your family doesn't know what you want, put it on your worksheet so that we can help you find the right way. Okay. And Molly said, I want Mark to be the guardian. Even though Mark's a stepdad, they're close, he does a great job, I'm choosing who's the guardian for our child. And that lets grandma remain grandma. So she can have him, she can take him fishing, she can take him on vacations, but she can go back to being grandma, and she's not an 83-year-old woman raising a 15-year-old boy, which could be problematic. She would, she wanted to, she loves him, but because Mark's doing it, he's better suited, and Molly made that decision for her son. And Molly said, I want the vacation home to be given to Mark, and it stays in the family. And she made plans for some extended ownership of that if something happens, like what's going to happen on sad day number 5. This is it. This is it. Who's left? Who's left? Okay. Mark lives a long life. Okay, I didn't kill him real fast. He lives a long life. And after everything he went through with Molly, he still delayed and didn't get his estate planning in place. And so when he passes away, we get a call from the adult children. They're in their 30s now. And who comes first? The IRS, we know that.
Yeah.
I can't change that for you. I can make it better, but I can't change it. I'm just going to take a break from the Bliss family and ask you, Prince had a $3 million estate. How much did the IRS get?
How much did he have?
300 million. Did I say 3 million? Ah,
Yeah.
Prince was dead. No, he had a $300 million estate. And how much did the IRS get?
20%.
100 million. Pretty good guess. They got 120 million.
Wow. That's a lot.
And he could have changed that. He couldn't have changed it where they got nothing. But he could have done some extensive planning, and he could have whittled this down by spending time with his lawyers, spending less than 120 million with his lawyers, and getting a good estate planning in place, and causing some different things to happen. I'm not going to go into all those details because that's a lot of advanced planning, but you don't want to pay the IRS. And right now, the number is 40%. 40%. You guys earn this money, you pay 40%. You die, they want another 40%, meaning you lived on 20%. Did I get that right? Is my math right? Okay, but we can do some things with that. And none of you right now, maybe I can't say none of you, right now, with the exemption being at 26 million per couple, raise your hand if you're over that and you don't have a plan in place. We need to talk to you in the next 10 minutes. If you're under that, you have an exemption. We can talk to you in the next month or two and keep you out of trouble. So in this case, alrighty. So because Mark didn't have a plan in place, the kids just got the distributions outright. But remember, Alexander wasn't his kid. So Alexander didn't get anything from Mark because he didn't write it down. Even though he loved him, he raised him, he wanted him to have something, but the stepkids don't get anything. If you have stepkids, you want them to do something, you want them to have something. If you're a blended family, you want to make the distributions in a certain way, write this down on your worksheet, because that's something very important, because you could end up acing out half of your family by dying in the order that causes that to happen. Let's do something for the Bliss family. Okay, we minimize their estate taxes by doing some advanced planning for them, by taking some things out of their estate and making them under the estate tax exemption, and the other items that they no longer own because they weren't in their estate are distributed separately. We also did lifetime asset protection trusts for the kids. And what does that mean? That means those kids, for the money they inherited, first of all, he included Alexander, because he loved him and because Molly wanted to. That means the kids, when they get their money, it's not an outright distribution. They can use that money, but the money that is held in that trust for them is asset protected. And wouldn't all of us like to have an asset protected trust where you're insulated from creditors, bankruptcy, lawsuits, all of the above? So that's what they did for their kids. And so they have a pocket of money for their use that their ex-spouses can't get to, that if they ran their credit cards up too high, they have a cushion to bounce into. So that's what they did for their kids. And that's a really nice gift that they gave to their kids by some very straightforward planning. Now the IRS still got their cut, but not as much. And the pets, because they made plans for their pets, they go to the person they chose. Maybe they gave some money for some vet bills and things like that. All right.
I never thought of the fact that dogs would also be considered.
They're important. I mean, cats too. Maybe you're not a cat guy. But I mean, Whiskers is a cat in this case. All right. Truthfully, what's important when something happens to you is your family's going to miss you. And that's going to be the focus of what's happening. And then they have all of this financial stuff and all of this crazy stuff and judges and creditors and lawsuits. And that's really not what you want to leave for them. And that's not what you're going to leave for them. And what's even more important than all of the money and everything that you've worked for your family are your values, your insights, your values, your stories, and your experiences. And we'd like to record that for you so you have something to give to your kids. What you live by and giving that to them is invaluable. What your parents gave to you that you bring forward, your family stories, those aren't alive anymore unless you give them to your kids. So some older, some younger, but these are the reasons why we're here. So if any of these things are important to you, put them on your worksheet. And let's have a conversation. Lesson number one from this, you need to review all of your assets and make sure they're part of your estate and this part of your estate planning conversation. And the way we do that is through an asset spreadsheet. Putting them on there allows your family to know what you have. Because if you don't list it, what if you got that promotional account at Chase because they were offering $300 and you didn't write it down anywhere and your family doesn't know that you have this promotional account at Chase and now it has 10 grand? Where does it go if they don't know? The state, look it up, there's 2.2 plus billion in unclaimed assets. You don't want one penny of your money to go there. That's what the asset spreadsheet does for you. Number two, the only person other than you who can make your decisions is a judge. If you let that happen, and you don't want that to happen. So I'm going to talk a little bit about our law firm and what we do at Truist Law and why we're a little bit different. Actually, we're a lot different than other estate planning firms. We're a flat fee law firm. So remember that $75 you got because the lawyer was talking to somebody? Doesn't happen. 10 minutes? Okay, we might make it because we killed everybody in this family. All right, we want to be around with you for your life so that your family has somebody to rely on. They have somebody to call when something happens to you. My mom's in the hospital. Who's supposed to make the decisions? Where do I find the book? Oh, we have a copy here. We can send that out. We can get in touch with those people. Oh, it's you? Okay, let me get that out to you. And then you're at the hospital, you're able to make those decisions. You have a copy on your phone. And your mom and dad would have given you a copy, or we'd have given you a copy, but you would have lost it, and that's what we're here for. So, and we don't charge you another $75 to get that copy. We keep in touch with you, both during your planning process and after your planning process, to make sure that your plans are updated. Because if you don't have an updated plan, the wagon, all of those assets that were outside the wagon, that's what starts happening over time. And if you have grandkids, and you didn't have grandkids when you did this, might want to include them. So we want to make sure we're updated Those are why plans fail. You don't have one, they're not funded, and they're not updated. Otherwise, working with us and getting that started, you will be in good shape. Staying with us, you stay in good shape. We also do the legacy interviews. That's so your family does know your family values. We include a family meeting so that we talk about, and this is not the place where we disclose to the kids that you have $100,000 and number 5749 of Bank of America. This is where we tell the kids, we made a plan for you. We love you. We made this plan for you because we love you. And it's to make things easier for you when you're truly in grief. For the minors, for people with minor children, we do the kids protection plan, and that includes the long-term guardians that you have, that you want if something happens to you, who you want to raise your kids. But it also includes those short-term guardians like Dina, who was on the trip with them. Maybe she's not a candidate to raise those kids long-term, but she's better than DCS, better than the state. And these kids were in California or Nevada, depends on where they were in Lake Tahoe. They weren't even in Arizona, so they weren't even in the right jurisdiction. So you've got some judge who has nothing to do with these kids making a decision, even worse. And our plans, what we do for you, are custom designed for your family. They're not a cookie cutter. They're not spit out of a service that is an online service, because those may be a trust, but I can't tell you that those will work for your family. Our plans will work for your family and meet your family's needs when they need it most. And this is what a regular law firm looks like. Usually hourly fees, so you don't know how much it's going to cost. Depends on how much you talk to them. So if you don't talk much, it kind of keeps you from talking to them, keeps you from asking questions, keeps you from getting your questions answered. They're kind of a one-off transaction. They give you your book and you're out the door. We don't do that because you know what? If you do that, you'll end up in probate. Your family will end up in probate, either when you're disabled or when you die, because your book won't work. And if you do get the plan finished, you have an expensive stack of documents. There's no support in funding. We will support you in funding, and your assets won't go into that wagon, and you need to get your assets in the wagon. So ultimately, a traditional experience is people end up with plans that they haven't funded, that they didn't put their assets into, or they have them sitting on their shelf in draft. Do any of you have that, where it's sitting somewhere and you never return to the lawyer and sign the plan? That's a typical experience as well. So here it is side by side, them and us. And what we promise you here is that your estate plan will get done. We might have to pull some teeth out of you, but we will bug you until it gets done. And it will cover everything you need for the peace of mind that you need and that your family deserves, so that you know your plan will work when your family needs it most. So how can Truist Law be of service to you? If you click on this one, Kirstin, lady in the back of the room, passing everything out, collecting your worksheets, you can schedule a 15-minute call with Kirstin, see what your issues are, note them on your worksheet, turn them into Kirstin, and we can see what your needs are and if it's something we can help you with or guide you. Maybe you're not ready to make a plan today. Maybe you want to talk about, I have these assets and I have this beneficiary, and let's talk about a beneficiary deed. Those are great until you die with your beneficiaries, and then your family's back in court. So you want to plan a little bit more extended than that, especially with your house, especially with your bank account. If you know you're ready, you can click that link and she can make an appointment for us to get started. But I think the first thing you want to do, the 15-minute conversation, you're not committed to planning with us. Just have the conversation, see if it's something you're ready to do, something you want to do. I want to tell you, I'm going to give you full transparency what everything costs here, and I'm going to describe to you the process here. That's why the 15-minute call is good. We start with what we call a family wealth planning process, family wealth planning session. And that is where we get to know each other. You have filled out information about your assets, and we talk about where you stand today, where you are without a plan, how it's going to go in probate, who's going to get your kids, who's likely to get your kids. We don't know which judge is going to decide, but we know some judge is going to decide. Then at that second part of that meeting, if you go forward with us, you design your trust. Now that's not written in stone that day because trusts are important and they take some time to think about. So we take about 8 weeks as our usual process. If you come back in about 4, oops, circle number 2, and you sign your trust. On that day, you're covered and your house is in your trust because we put your house in your trust. And then you get the homework shifted back to you for another 4 weeks, and you go about designing or funding your assets into your trust. I've gone back too far here. And as you're funding your assets into your trust, you're calling us and you're getting support on how to do this. And we help you break it down into sections and help you fund it. And you have a toolkit that helps you do that. All right, so how much is this going to cost? First of all, less than probate, always, ever. We have 3 planning sections. We have a family plan that ranges from $2,500 to $4,500. We have a trust plan that includes a trust. That ranges from $4,500 to $6,500, and we have a legacy plan. And you'll notice that the legacy plan is $3,000 difference. That's with us doing the funding of your assets to your trust. Most people don't need that. So today you've saved $3,000 because you don't need us to do that. However, the family plan is for families who aren't yet ready for a trust, but that they need their kids protected. They do need a will-based plan, and they will probably move into a trust plan as their assets grow. So I've already told you about the next 3 slides, so there you go, and how much they cost. Okay. If you want to plan today, if you know you're ready, we're offering this. We usually charge $750 for our initial family wealth planning session, but we will waive that for you. If you send clients to us, we will waive that for your clients as well. And that gets them financially organized with that asset spreadsheet, and they know where they stand at the end of that session. If they decide to plan with us, then they will get an additional, and you will get an additional $250 off your plan. Okay, so these are just some reviews. You can see what some of our other clients have said. I think this one coming up is my favorite. Nate didn't want to do the legacy interview because he was kind of a tough guy and he thought he might cry and he didn't want to think about a time when he wasn't here. And I had one of our other attorneys, I think she squeezed his pinky with some pliers and made him do it. And Nate turns out to say that was the most valuable piece of that. He has the peace of mind, but it was actually the legacy interview that was the best part. Now, I don't advocate, and I don't actually put your pinky in pliers, but I don't know why Trisha did, but she did. Oh, yeah. Well, Trisha did a lot, but we encourage you to do this because it is so important for your family. Because if something happens to you and you're a new or young grandma, they don't remember you, and you've given them family values. You've given them what's really the most important part about your family, and it's not your house. That's wonderful that you built that estate and you left that for your family, but really what they need to know is who you are. And Nate said it best, but I think this is very funny because he was the one who definitely was not going to do that. So these are just some reviews, and I wanted to thank you for coming here. Did I slide in under my 10 minutes? Okay.